This law lays out that the amounts perceived by an entity established out of France in payment for services returned to France by a person with an ordinary residence in France or not, are taxable in the name of this person in 3 cases. First, this person holds directly or indirectly the entity which receives the payment of the services. Second, it is not proven that the intermediate entity carries on an industrial or commercial activity different from the performance of these services. And third, the intermediate entity is established in a state where it is subjected to a low tax system. This law targets, in particular, artists or sports people who generally entrust the management of their rights to an intermediate company often based abroad. For singers or artists, it is often about the remuneration of their artistic services. And for the well-known sportsmen, actors or models, it can be their rights to image. Article 155A allows to tax in France this remuneration in the name of the celebrity in question, when they are paid through an intermediate entity, a player's agent, for instance, located abroad. For example, I can evoke a recent file I had to treat where the administration won the case before the court. As this decision has been published, I dare to give you the names, even I should have many enemies tonight. And please mark. Keep your red card in your pocket. It is about a Brazilian football player, Mr. Edmilson Gomes of Moraes, called Edmilson. I don't know who is he famous, which played between 2000 and 2004 with the French club Olympique Lyonnais. He had entrusted to a British company named Chatterella Investors Limited the management of his rights relating to the use of his name and image. Chatterella has then reassigned temporarily these rights to the Olympique Lyonnais with the help of a yearly rental of $440,000. On behalf of the Article 155A, we taxed these royalties in the name of Edmilson because of the fact that Chatterella was a screen company which did not have any other activity than to receive the royalties in question. Edmilson claimed that he had completely yielded his rights to the company Chatterella and that he had not carried out any service in France. Moreover, he said that the French tax authorities did not show that he had received these amounts. The judge considered that the image and the notoriety of a professional sportsman cannot be separated of his sports activity, and then he had truly carried out the service. In the same way, he considered that Article 155A allow the assessment in the hands of the real person receiving profits, even if he had not them in his pocket directly. All these rules have a great merit. They give to the economic operators some precise rules for the game. and the operators who deviate somehow know the risk they incur. But they, however, have a disadvantage. They do not make possible to face all the situation of tax avoidance. As the tax lawyers' imagination is fertile, they always have a little advance on the legislator's reaction. The primal reaction consists in amending the law in order to make possible for the tax authorities to fight the avoidance schemes lately discovered. Then the legislator works out a regulation even more precise, but the taxpayers discover new means of passing through the meshes of the legislative net, which involves a new but always late reaction of the legislator. And this little game can be carried out ad infinitum. The need for another response is essential. This comes from the idea that the right stops where the abuse starts, and then the fraudulent use of the legal system represents an offensive against it. Generic defense systems are therefore essential. They constitute a first step of the marginalization of the legal rule. In France, such arrangements entered the tax doctrine under the name of fraud to the law or abuse of law and abnormal management act. What are those widened measures? The abnormal act of management theory. In France, like in many countries, the law provides that for the determination of taxable profits, the expenses can be deducted only if they are paid in the interest of the business or in the frame of a normal management. Then it is possible for the authorities to question any transaction which would not be related to a normal management. This principle of abnormal act, the term act being understood as action or decision, is called upon by the authorities, for example, when expenditure carried out by a company has profited to its directors or shareholders without any consideration with provided services, or consist on purchasing goods which are not useful for the business, or are considered as liberalities, or cost without any connection with the business line. Amongst the cases of application of this principle to the international business, it can be noted the remission of debts to parent or dependent companies, the existence of costs supported by a company because of the loans authorized without interest to a foreign company, or the services provided to a foreign company without requiring any advantage. This theory is indeed very useful for tax auditing, but it is a source of numerous litigations, not easy to defend because the analysis of the concerned facts is obviously subjective. A few words now about the abuse of law principle. Authorities, in theory, must respect the situations of right as they are presented. The deeds are supposed to be sincere and normally balanced when they consider reciprocal liabilities. But under the terms of its general capacities of control, the tax authorities have the right to restore their real character to operations which, under cover of deeds or unspecified contracts, resulting to make failure with the tax law.